My
All right, pause right here. Because when Judge Boyd comes back on the bench, the temperature in the courtroom drops immediately. This isn't the let's hold hands and talk about growth judge. This is the you've been here before and I remember you judge. And that matters because judicial memory is very real. If you're a repeat probation violator, credibility is already on life support. Question for you. If you were the judge, would you still be listening or already?
Received a note that you refused to take a drug test.
yes, ma'am, because I leaned against the thing. I just finished sneezing back there, and I felt like I was being singled out. I know I have alcohol in my system
So
from
here,
the night before.
so let me explain. If you don't test
Mhm.
and let me see what is or is not in your system, then I'm going to assume that you're positive,
Okay.
and I will raise your bond for sure, and you'll go to jail.
Okay.
So do you want to take the test and let me see what's in your system?
I don't have anything in my system besides alcohol.
Then go take the test.
I can't pee.
We're going to give you some water.
I just had water.
Then you want me to go ahead and send you to jail?
I don't know. You haven't even finished running down my charges to me.
What?
Running down my charges to me.
What do you mean?
What I was here for, or if I'm going to get a lawyer, and all that.
First things first is I'm ordering you to take a drug test. If you refuse the
This is the legal gut punch. Motion to revoke probation isn't a warning, it's the state saying, we're done negotiating. At this stage, the defendant isn't presumed innocent of the violation. The court just needs to believe it's more likely than not that probation was violated. That's a much lower bar than a trial. Translation, the defense is already uphill and flip-flops during a storm.
then take the drug test. So either there's something in your system other than
I have
alcohol.
something in my system. I
Right.
said that.
You said you have alcohol.
Yes, ma'am.
I'm not worried about that right now.
Maybe some weed.
Take the test. Let me see what's in your system.
It's weed.
Okay. I want to see what's in it. Take the test. And then we'll decide. Just because you test positive does not necessarily mean that I'm going to raise your bond, but we're going to have some discussions depending on what's in your system. So if you want any opportunity today to walk out that door instead of that door, go take the test. Otherwise, I'm raising your bond right now.
I can sit and see if I can pee.
Go try. Justin Wallace with Mr. Lewis. Okay, so you've refused again.
I didn't refuse. I told him that I couldn't go. I didn't refuse for the sake.
There's no way that after a couple hours you can't go a little bit. So I'm going to find Miss Paul based on.
And this is where the emotional argument quietly collapses. The defense leans hard on sole caretaker, a powerful plea, but the judge just identified an alternative caregiver. Once that happens, the court's focus snaps back to one thing: public safety and compliance. Tough question for viewers. Should personal hardship outweigh repeated violations, or does probation only work if there's a hard line?
Your current bond that you. I need to take a look at probable cause affidavit. Give me just a minute to get more information about you and your case, and then I'll decide what to set your new bond at.
Miss West, can I say, I know that I'm going to jail today. That's fine. But I feel like I've been the victim in this and I have the proof. I'm just overwhelmed at this point with the whole situation.
Well,
because the girl is still harassing me.
Have you called the cops?
No, but I have the proof of her going to my job recently. Letters from my job and her job.
All right, just hold on. You're going to need to tell all that to a lawyer. That's. You still have that assault down the hall pending?
I have to go to that courtroom for the same person.
All right, so based on the limited information that I have,
Procedure. Jeez.
I'm going to again find that you violated the conditions of your bond and in cause number 25 DCCR 1752, raise that bond to $35,000. A condition of that bond, if you make it, is that you have to have a drug patch put on within 24 hours of your release from custody.
Okay.
And obviously, if you get out soon, I'm going to assume that that drug patch will initially be positive,
Okay.
but it should be going down. So it doesn't just test whether you're positive or negative. It gives me an amount.
Okay.
And if it's not going down, then that bond's going to go up even higher. Do you
Okay.
understand?
Yes, ma'am.
If you
Yes, credit for time served and inpatient treatment helps on paper, but this is still a 2-year prison sentence with an affirmative finding of family violence, which triggers lifelong consequences, no firearms, limited appeal rights, and permanent felony status. This moment right here, this is the cost of one more chance being asked too many times. Final takeaway, probation isn't about promises, it's about patterns.
don't get the drug patch changed every 2 weeks like you're supposed to, some people say, oh, it
Good morning.
Good morning. Why wouldn't you take that off when the bailiff asked you to earlier?
No, I had told because I had this on. I didn't want to take it off.
I understand, but it's not appropriate and you have to do that and follow the rules. It's not just when you're standing in front of me, but when you walk into the courtroom, there's no head. You should have known better than to wear a bonnet to court in the first place.
Yes, ma'am.
Right? This is felony court, not where you show up in a bonnet.
Yes, ma'am.
So